Good morning, everyone. Today we discuss the chapter 3 entitled Legal, Ethical, and Professional Issues in Information Security. As a future information security professional, we need to understand the scope of the company's legal and ethical responsibilities. Information security professionals play an important role in the company's approach to managing privacy and security risk responsibilities. In modern judicial societies around the world, the law is sometimes applied to civil courts, in which the plaintiff who filed a lawsuit against the organization can obtain huge compensation. Sometimes these losses are punitive and viewed as a deterrent. Minimize liability, reduce risk from electronic and physical threats, and reduce all losses. Starting from legal proceedings, information security practitioners must have a thorough understanding of the current legal environment, keep pace with laws and regulations, and be vigilant against emerging issues. Organizations must comply with their legal and ethical obligations and ensure the correct use of information technology and information security, professional security that can help organizations focus on their core tasks. Law and ethics in information security. Usually, people are more willing to trade certain aspects of individual freedom in exchange for social order. As Jean-Jacques Rousseau explained in The Social Contract, or Principles of Political Law, members of society formulate a balance between individual rights and freedoms. The definition that meets the needs of the entire society is called law. Laws are rules that impose or prohibit certain behaviors. They are based on ethical norms that define socially acceptable behavior. The main difference between law and morality is that law has the authority of a governing body, while morality does not. Some moral standards are universal. For example, murder, robbery, assault, and arson are behaviors that deviate from moral and legal norms around the world. Organizational liability and the need for counsel. What if the organization does not require or even encourage employees to adopt strict ethical behavior? What if the organization's behavior is unethical? Even if the criminal law is not violated, liability may still arise. Liability is the legal obligation of a legal person, content beyond the scope of criminal law or contract law. It includes legal obligations to remedy or replace violations committed. The bottom line is that if an employee engages in illegal or unethical behavior with or without the employer's consent, if he refuses to conduct the so-called due diligence, it will cause a certain amount of damage and the employer organization will increase its liability. When the organization ensures that every employee knows what is acceptable or unacceptable and understands the consequences of illegal or unethical behavior, you comply with due diligence standards. In the legal system, if any court can establish jurisdiction, it can exercise power over individuals or organizations. Jurisdiction, a long branch of law that extends to a country or all over the world, bringing the defendant into its judicial system. Dealing with the case in the victim's place of origin usually benefits the victim. Policy versus law. In an organization, information security professionals help maintain security by creating and executing policies. These guidelines describes guidelines for acceptable and acceptable behaviors of employees in the workplace. As the law of the organization, it has sanctions, jurisdiction, and sanctions to enforce them, because these policies operate like laws. They must be designed and implemented in an equally careful manner to ensure that they are complete, consistent, and fair to everyone in the workplace. However, the difference between politics and law is that ignorance of politics is an acceptable defense. Therefore, for a policy to be enforceable, it must meet the following five criteria, which is dissemination, that an organization should be able to demonstrate that appropriate policies have been provided to the employees for review. Common distribution methods include hard copy and electronic distribution. Second is the review, that an organization must demonstrate that it distributes documents in an understandable manner. including versions for illiterate, non-English employees who have difficulty reading. Common methods include policy records in English and other languages. Next is the comprehension which an organization must demonstrate that employees understand the requirements and content of the policy. Common methods include questionnaire, surveys, and other assessments. Fourth, the compliance which an organization must be able to demonstrate through actions or statements that employees agree to comply with the policy. Common methods include a login banner that requires action to confirm the agreement, or a signed document that clearly states that the employee has read, understood, and agrees to comply with the policy. Lastly is the uniform enforcement, which the organization must be able to demonstrate that the policy is consistently applied regardless of the status or distribution of employees. Types of law. Civil law includes a wide range of laws governing a country and regulates the relationship and conflicts between organizations and individuals. The criminal law deals with behaviors that are actively implemented by the state to disrupt society, as private or public. Private law includes family law, commercial law, and labor law, and regulates the relationship between individuals and organizations. Public law regulates the structure and management of government agencies and their relations with citizens, employees, and other governments. Laws include criminal law, administrative law, and constitutions. General computer crime laws. People who live or work in the United States are particularly concerned about several important information security laws. The Computer Fraud and Abuse Act of 1986 is the cornerstone of many federal computer laws and was amended in October 1996 through the National Information Infrastructure Protection Act of 1996, which revised several parts of the previous law and increased punishment. Another key law is the Computer Security Act of 1987. It was one of the first attempts to protect federal computer systems by establishing minimum acceptable security practices. The United States Patriotic Act of 2001 supplemented previous laws and many other laws, giving law enforcement agencies more freedom to combat terrorist activities. In 2006, the American Patriot Improvement and Reauthorization Act revised the law, which allowed 14 of the 16 expanded powers of the Department of Homeland Security and the FBI to be permanently used to investigate terrorist activities. Privacy. Privacy has become one of the hottest topics in the field of information security in the early 21st century. Many organizations collect, trade, and sell personal information as commodities, and many people turn to the government to protect their privacy. In response to the pressure to protect privacy, the number of laws governing personal privacy rights has increased. However, it should be understood that confidentiality in this case is not absolute freedom of observation, but an exact state of life. Avoid unauthorized interference. To help you better understand this rapidly evolving issue, here are some of the most important privacy laws.
Privacy of customer information. Certain provision of the United States stipulate that ordinary telecommunication operators have the responsibility to protect the confidentiality of the customer information, including information from other operators. The privacy of customer information section on the confidentiality of the customer information stipulate that all proprietary information is clearly used, provide services, and must not be used for market purposes. Operators shall not disclose the information unless it is necessary to provide it. Although the Public Carrier Regulation governs the privacy protection of the state airlines, the Federal Privacy Act of 1974 governs government agencies and requires them to be responsible for unauthorized disclosure for personal information about individuals or companies. The Electronic Communication Privacy Act of 1986 is a series of law that regulates wiretapping, electronic and oral communications. These laws are used in conjunction with the Fourth Amendment to the U.S. Constitution, which protect people from illegal searches and seizures. The Health Insurance Portability and Accountability Act of 1996, also known as the Kennedy-Kasboum Act, protects the privacy and security of medical data by setting and implementing standards and standardizing electronic data exchanges. The HIPAA has 5 fundamental principles. First, consumer controls of medical information. Second, boundaries on the use of medical information. Third, the accountability for the privacy of private information. Fourth, the balance of public responsibility for the use of medical information for the greater good measured against impact to the individual. And lastly, fifth, the security of health information. The Financial Service Modernization Act of 1999, or the Gramm-Rich-Belley Act, contains many provisions designed to promote cooperation between banks, investment companies, and insurance companies. In particular, the law requires all financial institutions to disclose their privacy policies regarding the transmission of non-public personal data. Identity theft. More and more identity theft laws are related to privacy law. The Federal Trade Commission, or FTC, describes identity theft as one of use personal information such as name, social security number, or credit card number to commit fraud or other crime without their permission. Although many states were passed identity theft law, at the federal level, the main legislation is fraud and related identification documents, identity verification tokens, and the creation, reproduction, transmission, and possession, or use of false or unauthorized information as criminal information. Identification documents are document preparation equipment. Penalties of these crimes range from 1 to 25 years and fines are imposed by the court. Export and espionage law. In order to meet the national security requirements and protect the trade secret and other public and private assets, various law restricts which information and information management and security resources can be exported from United States. These laws are designed to prevent information theft by exposing heavy penalties on the promulgation of the Industrial Espionage Act of 1996 in order to protect the originality, intellectual property, and competitive advance of the United States to prevent the illegal dissemination of trade secrets, encrypt and provide protection from government intervention by law, reinforce an individual right to use or sell encrypt algorithm, cryptographic key, or its text equivalent, which another party to be used break the encryption of the data. This is often called the key exco. Prohibit the federal government from requiring the use of encryption for contract, grants, and other official documents and correspondence. It states that the use of encryption is not probable cause the suspect criminal activities. States that the use of encryption is not probable cause to suspect criminal activities. Relax export restriction by amending the Export Administration Act of 1979, provides additional penalties for the use of encryption in the commission of criminal act. The U.S. copyright law. Intellectual property is protected asset in the United States. U.S. copyright law extended this privilege to published texts including electronic formats. Fair use allowed to use the copyrighted materials to support reports, training, scholarship, and etc. Activities used for educational or library purposes are non-commercial or non-excessive, provided that the reasonable recognition is provided to the original author of this work, including a full description of the location of the source materials, and the work are not submitted by themselves, restrictedly insert some of the works of other as the references. The financial reporting. The Sarbanes-Oxley Act of 2002 is the main law affecting the management of listed companies and auditing companies. The law aims to improve the reliability and accuracy of financial statements and strengthen the accountability of corporate governance. Penalties for non-compliance range from fines to imprisonment. Executives of companies subject to this law require senior IT manager to ensure the reliability and quality of information system. Similarly, IT managers are likely to require information security managers to verify the confidentiality and integrity of this information system in a process called sub-certification in industry. Freedom of Information Act of 1966. The Freedom of Information Act allows everyone to request access to any federal agency's file or information that not considered as a national security issue. Federal agency must provide the requested information after receiving the written request. This requirement is enforceable. However, some information is protected from disclosure. The law does not apply to state or local government agencies, private companies, or individual, although many states have their own version of FOIA. State and local regulation. In addition to national and international restriction on the use of information technology is an organization, each state or city can use its own applicable law and regulations. Therefore, information security professional must understand national law and regulation and ensure that company security policies and procedures comply with this law and regulations. International law and legal bodies. IT and information security professional must understand that when their companies operate on the internet, they do so globally. Therefore, these professionals must be sensitive to the legal and moral values of many different cultures and societies. It may also be impossible to please everyone, but dealing with this law of other states and nations in an area where ask for forgiveness is certainly not easier than asking for their permission.
European Council Cybercrime Convention. The European Commission adopted the Cybercrime Convention in 2001 and established an international working group to oversee a series of internet-related security functions to achieve standardized technical laws across international borders. The treaty emphasized the prosecution of copyright infringement, so it was well received by intellectual property defender. However, many human rights defenders oppose the convention because they believe it inappropriate violates freedom of speech and threatens civil liberties in the United States residents. Like very complex international law, the Cybercrime Convention lacks realistic implementing provisions. The general purpose of the convention is to make it easier for the law enforcement agency to obtain information about certain types of international crimes. It also simplifies the extradition procedure. There are many skeptics on the convention who think it is an oversimplification attempt to solve complex problems. Agreement on trade-related aspects of intellectual property rights. The Agreement on Trade-Related Intellectual Property Rights, established by the World Trade Organization and concluded in 1986 to 1994, introduced intellectual property rules into the multilateral trading system. The WTO and TRIPS agreement covers 5 issues. First is how basic principles of the trading system and other and international intellectual property agreements should be applied. Next is how to give adequate protection to the intellectual property rights. Third is how countries should enforce those rights adequately in their own territories. Fourth is how to settle disputes and intellectual property between members of the WTO. And lastly is special traditional agreement during the period when the new system is being introduced. Digital Millennium Copyright Act. The Digital Millennium Copyright Act is the United States contribution to the international effort of the World Intellectual Property Organization to reduce the impact of copyright, trademark, and privacy violation, especially when it is achieved by removing technical copyright protection. The DMCA includes the following preventions. First is prohibits the circumvention, protection, and countermeasure implemented by copyright owner to control access to protected content. Next is prohibits the manufacture of device to circumvent protection and countermeasure the control access to the protected content. Next is bans trafficking in device manufactured to circumvent protection and countermeasures the control access to the protected content. Next is prohibits the altering of information attached on embedded information copyrighted material. Last is includes internet services providers from certain forms of contributory copyright infringement. Ethics and Information Security. The Ten Commandments of Computer Ethics. From the Computer Ethics Institute. Thou shalt not use a computer to harm other people. Thou shalt not interfere with other people's computers' works. Thou shalt not snoop around in other people's computers' file. Thou shalt not use a computer to steal. Thou shalt not use a computer to bear false witness. Thou shalt not copy or use proprietary software for which you have not paid. Thou shalt not use other people's computer resources without authorization or proper compensation. Thou shalt not appropriate other people's intellectual output. Thou shalt think about the social consequence of the program you are writing or the system you are designing. Thou shalt always use a computer in ways that you ensure consideration and respect for your fellow humans. Ethical differences across cultures. Cultural differences can make it difficult to determine what is unethical, especially when you're using computers. Research on ethical and computer use shows that people of different nationalities have different views. Difficulties arise when the moral behavior of one ethical group violates the morality of another ethical group. For example, in the Western cultures, many uses of computers technology and Asia cultures are software piracy. This ethical conflict stems from the Asian collective property tradition and conflict with with the protection of intellectual property rights. Approximately 90% of software was created in the United States. Some countries have looser restriction on copyright intellectual property rights than others. Ethics and education. Attitudes to the ethics of computer use depends on of many factors other than nationality. There are differences between people, social classes, and companies within a country. Key research shows that education is an important factor in the adjustment of moral belief in a small group of people. Employees must be trained and understood many information security issues, including the expected behavior of ethical employees. This is particularly important in the field of information security because many of employees may not have received formal technical training and cannot understand that their behavior is unethical or even illegal. Appropriate legal and ethical training is essential to create informed, well-trained, and low-risk user of the system. Deterrence to unethical and illegal behavior. There are three general causes of unethical and illegal behavior. First is ignorance. This law is not an excuse. However, there is a lack of understanding of policies and procedures. The first method of containment is education. This is an accomplished by the means of designing, publishing, and disseminating organization policies and relevant laws, and also obtain agreement to company with these policies and laws from all members of the organization. Next is accident. Individuals with the power and privilege to manage information in the organization are more likely to cause injury or accidental injury. Careful planning and control can help avoid accidental changes to system and deterrence to unethical and illegal behavior. There are three general causes of unethical or and illegal behavior. First is ignorance. This law is not an excuse. However, there is a lack of understanding of policies and procedures. The first method of containment is education. This is accomplished by means of designing, publishing, and disseminating organization policies and relevant laws, and also obtaining agreement to company with this policy and laws from all members of the organization. Next is accident. Individuals with the power and privilege to manage information in the organization are more likely to cause injury or accidental injury. Careful planning and control can help avoid accidental changes to system and data. Next is intent. Criminal or immoral intent affect the mental state of the offender. Successful prosecution of the perpetrator usually required criminal intent. The best way to protect the system from those who want to cause harm is through technical controls and strong legal action or prosecution when there is controls failed. Regardless of the cause of illegal, unethical behavior one thing is certain: information security workers must do everything they can to prevent such behavior and use policies, education, training, and technology to protect information. However, the law, and guidelines and related sanction will only be blocked if the following three conditions are met. First is fear of penalty. Potential offenders should be punished carefully. The threat of informal condemnation or verbal warning may be different from the threat of imprisonment or loss of wage. Next is probability of being caught. Potential criminals need to believe that they may be caught. Sanctions will not be prevent illegal or unethical behavior unless there are legitimate reasons for fear of being caught. Last is probability of penalty being administered. Potential offenders must be believed that sanction will be implemented. Codes of ethics and professional organizations. Several professional organizations have established codes of conduct ethics. Codes of ethics can have positive effect. Unfortunately, many employers do not encourage joining this professional organization. It is the responsibility of security professionals to act ethically and according to the policy of employers, professional organization, and laws of society. Professional organization with codes of ethics. Many lending IT organizations abide by their own ethical codes. Professional organization. So if you can see here at the table, Association of Computing Machinery, Information System Audit and Control Association, Information System Security Association, International Information System Security Certificate Consortium, and Institute of Global Information Assurance Certification. So that's all. Thank you. Thank you for listening. Thank you so much. Good day. Keep safe.